Thank you.
All right, well, I think we might as well start. We've got a fair amount to get through. So welcome to you all to this Australian Academy of Law event, advertised as Class Actions Exposure Draft Bill concerning third-party litigation funders. But as Kate Morgan will explain, you can delete the exposure draft. We've now got the bill itself. My name's Alan Robertson. I'm the President of the Australian Academy of Law. And on behalf of the Academy, I acknowledge and pay my respects to the traditional owners of the lands on which we meet, and in particular, I pay my respects to the Gadigal people of the Eora Nation, the traditional owners of the land from which I am speaking to you. First, a few words about the Australian Academy of Law. It was established in 2007 as an independent, permanent national body comprising distinguished lawyers from, importantly, the judiciary, academia, and the practicing profession. And membership is by invitation of the board of directors following nomination. The Academy of Law is registered as a charity and has DGR status under the Income Tax Assessment Act. It was established because there was no independent organisation that constituted a bridge between members of the judiciary, the academy, and the practicing profession. And through these events and otherwise, the Academy of Law supplies that bridge. So that's all I wanted to say by way of general introduction. Specifically in relation to the topic, this is, I think, the first time that the Academy of Law has organised an event to discuss a bill which is before the Parliament, Federal Parliament in this case. The Corporations Amendment, this is a study in itself, the short title of bills, the Corporations Amendment bracket, Improving Outcomes for Litigation Funding Participants, close bracket, bill, which was introduced into the Parliament, the House of Representatives, yesterday, as I understand it. The Academy of Law did hold a class actions forum earlier this year in July. You can still watch, if you want to see the picture as it then stood, the video recording of that event on the Academy of Law's website. The speakers then were Ms. Rebecca Gilsonen, Mr. Justin Gleeson SC, who's going to speak again tonight, Mr. Jason Betts, and Ms. Susanna Taylor. The difference is, of course, as I said, now we have the bill. After the question and answer session, and you can put your questions through the chat function, as explained, I think, in the email you have got earlier today. So after that session, you'll hear from Justice Tony Pasanko, the Deputy President of the Australian Academy of Law, will move the vote of thanks. So next and lastly from me, it's my pleasure and privilege to introduce Justice Jane Jago. I'm very grateful to Her Honour for agreeing to chair this event. As you will all know, she is widely experienced in class actions, both at first instance and on appeal. Justice Jago was admitted as a solicitor in 1991 and began her legal career at Mallison Stephen Jakes, as it was. In 1997, she became a partner of that firm, and after 5 years as a partner, she moved to the New South Wales Bar in 2002. She was at the bar for 4 years, and then in 2006, Her Honour was sworn in as a judge of the Land and Environment Court of New South Wales, and in September 2008, Her Honour was sworn in as a judge of the Federal Court of Australia, where she remains. She is a fellow of the Australian Academy of Law. So I hand over to Justice Jago, who's chairing the event. Thank you.
Thanks, Alan. Well, welcome everybody. I'm pleased to say we've got 4 people who will be really interesting speakers tonight. First, we'll hear from Kate Morgan, SC, who's a member of 10th Floor Chambers, and Kate practices in a wide range of areas, including regulatory matters, class actions, competition law, and others. She currently has class actions running in both the Federal Court and the Supreme Court, and she'll be talking to us first. Kate will be followed by Justice Gleeson, SC. He's a barrister, as we know, practicing in Australia, but also as an international arbitration practitioner. He was, of course, the Solicitor General of the Commonwealth of Australia between 2012 and 2016. His specialties include international law, arbitration, constitutional law, and appellate law. And he's, I know, got some very interesting things which I suspect have not been changed by the actual bill that's come out tonight. And then we'll be hearing from Justice Button of the Supreme Court of Victoria. Justice Button was appointed to that court in August this year, and before that she was a senior counsel at the Victorian Bar, practicing primarily in corporate and commercial law, including class actions. Last but not least, indeed, we have Nathan Rappaport, who's a special counsel in Slater and Gordon's class action group. And over the last 10 years, he's been representing plaintiffs and group members in class actions and large multi-party proceedings, and in many of those cases have been subject to litigation funding. So he will be particularly interesting to hear from that perspective. And over the last 3 years, Nathan's also been leading several of Slater and Gordon's superannuation class actions. So we welcome all the speakers. I think you've been told that there will be an opportunity at the end for questions. One of my functions, small functions tonight, is to just collate the questions on the chat function. So I'll be keeping an eye on that. So if you do want to ask a question, feel free to send it through. I'll collate them and we can deal with that at the end. Okay, so we'll hand over to Kate.
Thank you, Judge. Now, to set up the discussion that the panel will have and the matters that they'll cover, I'm going to give a very short outline of where the current bill is at and how we got to this point, and finally identify a few of the pressure points that various interested parties have identified in submissions to Treasury or otherwise. Now, first, as many of you know, nearly three years ago, the then Attorney General Christian Porter tabled in Parliament the Law Reform Commission's report called Integrity, Fairness and Efficiency, an inquiry into class action proceedings and third-party funders. Now, that report had 24 recommendations, and I'll just flag a few of them that are relevant for the current context. Recommendation 3 was that Part 4A of the Federal Court Act should be amended to provide the court with an express power to make common fund orders. Recommendation 4 was a recommendation that Part 4A should be amended to give the Federal Court, an express statutory power to resolve competing representative actions. Recommendation 7 was that the Corporations Act and the ASIC Act should be amended to confer exclusive jurisdiction on the Federal Court with respect to civil matters commenced pursuant to the Corps Act or the ASIC Act. Recommendation 8 was a recommendation that the Federal Court's practice note on class actions should include a clause for the court to appoint a referee to assess the reasonableness of legal costs charged in a representative proceeding prior to settlement approval. Now, the important recommendations in relation to litigation funders were contained in recommendations 11 to 16, and recommendation 14 was a recommendation to amend the Federal Court Act to provide the court with express power to reject, vary or amend the terms of any funding agreement. So we now see where the originating idea of what we see in the current bill has come from. Now, more than a year after the tabling of that Law Reform Committee's report, 14 matters were referred by the House on the 13th of May 2020 to the Parliamentary Joint Committee on Corporations and Financial Services. Now, the reason given for that referral was the existence of concerns that included the number of class actions, whether they are benefiting class action members, whether class actions, and in particular shareholder class actions, are in the public interest, and the size of returns to litigation funders and the current regulatory regime for litigation funding. Now, in 2020, before the Parliamentary Joint Committee finished its inquiry or published its or had its report tabled, in August 2020, regulatory amendments were made so that litigation funders were no longer exempt from the managed investment scheme provisions or other financial services regulatory oversight in the Corporations Act. So litigation funders, for example, were required from then on to obtain an AFSL. Now, on the 21st of December 2020, the Parliamentary Joint Committee's report was tabled in Parliament. Litigation funding and the regulation of the class action industry. Now, that contained 31 recommendations, and a lot of those recommendations, and I know many of you watching will appreciate this, quite a few of those recommendations seemed to not add anything to what was possible in the federal court and the various courts throughout the country in terms of the powers the courts had to regulate funders and regulate class actions generally. But some of the specific recommendations have been specifically referred to in the explanatory material on the exposure bill, and also more recently in the explanatory memorandum that we saw yesterday. Now, some of the specific recommendations were to amend the federal court's power in the Federal Court Act, dealing with resolving competing class actions, express powers in relation to closing class, resolving the uncertainty, as it was put in the recommendation, in relation to common fund orders. That was recommendation 7. That the court have the power to approve funding agreements to make them enforceable, and a power to reject, vary or amend the agreements. Now, the report also recommended some amendments to the Federal Court's practice note in relation to class actions, specifically for the appointment of referees as litigation funding fee assessors, and a presumption that a contradictor be appointed. And then finally, in recommendation 20, and I mean finally in terms of the ones that have been picked up more recently, the recommendation was that the government consult on the best way to guarantee a statutory minimum return, including whether that number should be 70%. Now, that brings us to the bill that was introduced yesterday into the House and the exposure bill that was circulated briefly for comment at the end of September. Now, when the exposure draft was released, the Treasurer and the Attorney General said in a statement that it would enhance court oversight of the distribution of class action proceeds between the funder and plaintiffs who are members of a class action litigation funding scheme, and further protect plaintiffs through the rebuttable presumption that a return to the general members of a class action litigation scheme of less than 70% of their gross proceeds is not fair and reasonable. Now, in yesterday's explanatory memorandum for the bill that was introduced to the House, it was more explicit about the managed investment scheme, the place of the managed investment scheme. The explanatory memorandum said the amendments establish a new kind of managed investment scheme, a class action litigation funding scheme, and introduce additional requirements for the constitutions of managed investment schemes that are class action litigation funding schemes. The measure ensures that returns to litigation funders out of the claim proceeds of a scheme are fair and reasonable. Now, the structure of the bill that we saw yesterday in terms of how it goes about regulating litigation funders is the same in its essential effect as it was in the draft. And so the way the legislation purports to work is that, first of all, it defines a class action litigation funding scheme. It imposes requirements on the constitution of a managed investment scheme that is a litigation funding scheme, including, and importantly, that a member of the scheme must agree in writing to be a member and to be bound by the terms of the Constitution. The media release that we had yesterday from the Treasurer specifically identified that the purpose of this structure was to encourage book building. The second step in the legislation is to declare funding agreements as unenforceable unless there is court approval in 3 different nominated instances, which in a federal court can't include a common fund order, which in the version that was introduced yesterday has been further refined in the language of what that means. As part of the approval, the court must obtain a referee's opinion and take into account contradictors' submissions, and this was referred to in the press release yesterday with specific reference to the Banksia decision in Victoria. Now, the third step is that the court must be satisfied that the proposed distribution is fair and reasonable, having regard only to the prescribed factors of what is called the fair and reasonable test in subsection 3 of 601 LG, and then subsection 5 imposes the rebuttable presumption that a return of more than 30% is not fair and reasonable. And we see there the inversion from the 70% return to members has now been inverted to 30% return to funders. Now, other than the general issue, the very important general issue of whether the bill achieves the stated purpose, which Justin will talk about in a minute, there seem to be at least 5 specific pressure points in the legislation. The first is the definition of a class action litigation funding scheme. Now, various submissions to Treasury, which I've had a look at, identified some concerns with the definition in the exposure draft, including whether insurers were included, whether philanthropic funders should be included. And we saw yesterday that the bill specifically excludes insurers from a managed investment scheme. Now, the second potential pressure point is the breadth of the application of the legislation, which purports to regulate funding agreements in matters even that are not in federal jurisdiction. The third is at what point one is addressing whether a claim, what the claim proceeds distribution model is, and is it about the claim as the distribution as between a funder and the members or as between members? And I'm not sure the new bill assists us in identifying some of those issues. The fourth potential issue, or a fourth potential issue, is the adoption of the closed class funding arrangement model. It was specifically referred to yesterday, as I've already mentioned, in relation to the book building. It seems to be at odds with the opt-out policy of Part 4A, even though it's not strictly inconsistent with that, and in particular the policy aim of finality through the class action process. And finally, from my perspective, both the constraint imposed in the bill on what a court may only take into account in determining what is fair and reasonable, and the 30% rebuttable presumption seems to reflect a very narrow focus of the drafters of the legislation and the government. And by that, what I mean is that the subject matter and causes of action that may be the basis of class actions are so broad, obviously beyond the shareholder class actions, which was a major focus of the Parliamentary Joint Committee report. One would think that it's vital that a court retain as much discretion as possible to ensure that class actions remain a vehicle, as we appreciate they are, for the pursuit of collective claims which are otherwise uneconomic to litigate. And there are understandably some concerns that these constraints on the court create sufficient uncertainty that the availability of funding for class actions will shrink as a result of this legislation. So on that note, I will hand over to Justin.
Thank you. Good evening, everyone. Hopefully you can hear me out there in the ether. Can you nod, Kate, to tell me you can hear me? Thank you. And thank you to everyone for coming along on short notice on this important occasion. The contribution I wanted to make this evening was to start with a question which hasn't been looked at terribly much publicly, but is an important question, is whether there is a constitutional source of power for this bill. Now, sometimes a loose view is taken that anything put in the Corporations Act is valid, either because it's under the corporation's power or it falls within the terms of the state referrals of power. This bill requires those assumptions to be looked at rather closely. If it's enacted, it will alter in significant ways that Kate has outlined the conduct and the outcomes of group litigation across all courts in Australia. Not just federal courts or state courts exercising federal jurisdiction, but even state courts exercising state jurisdiction. And it may be argued that its practical effect will be to significantly restrict the ability of ordinary Australians, many of whom are individuals, not corporations, to obtain access to justice under the open class action, which, as we know, has been a feature of the landscape for 30 or more years. There is therefore three questions to which you will not see any discussion or even attention in the explanatory memorandum that perhaps do need to be considered. The first is, can the corporation's power support the entirety of this bill? I suspect not. The second, which is harder, is whether the terms of the state referrals of power support the entirety of this bill. Those referrals relevantly support amendments to the Corporations Act in the area of corporate regulation or the regulation of financial products and services. Arguably, this bill speaks to that which courts may or may not do, and that which citizens may or may not do in seeking access to justice through the courts, which may go beyond those state referrals. The third question is that to the extent the bill purports to restrict what happens in state courts in state jurisdictions, there are questions to consider under both Chapter 3 and the Melbourne Corporation Principle. The second matter I wanted to turn to was that even if the bill is constitutionally valid, one thing that's missing from the explanatory memorandum is a frank recognition that the norms introduced by this bill will directly conflict in important ways with the terms of the Federal Court of Australia Act and with the equivalent state acts dealing with group actions. And indeed, they will actually produce, most probably, an implied repeal of the Federal Court of Australia Act, which is not a small step, and they will produce inconsistency with the state acts, which will render the state acts partially inoperative under Section 109 of the Constitution. Now, those are matters which the Federal Parliament can do, but I suggest they're matters which it should not do without due care and due consultation with the persons affected, which include the states and include the courts, federal and state. In the manner in which this bill is being, to put it frankly, rushed through Parliament, that consultation is not occurring. Tonight's seminar is a good chance for some of us to talk about the issues, but more attention is needed to them. And I would be urging those who listen that the bill at a minimum has to go into a committee for a lengthy process, but most probably should be withdrawn and rethought. Can I give two examples of that inconsistency? It's not simply a tension, but I think it is an inconsistency. The first is, as we know, that the statutory scheme for regulation of group actions, federal and state, is built around the open class action as the paradigm. It involves the court having an open worded power to approve settlements on terms that are fair and reasonable, including approving payments to those who have provided services which have produced the successful outcome, be they lawyers, funders or otherwise. It includes, on the High Court's discussion in BMW and Brewster, at least the power for the court to make a fund equalisation order, FEO, whereby persons who haven't signed up to the funder's terms can be ordered to pay something against their will. And at least arguably it includes the power to make a CFO, or that question still awaits the High Court's decision. Yet, and Kate alluded to this, the avowed intent of the bill, if I could just read out paragraph 1.35 of the EM, is that it ensures that a claimant cannot be co-opted into becoming a member of the scheme and therefore subject to contributing to the funder's remuneration without their active consent. Now, whether the bill completely achieves that stated objective in its drafting is a matter for debate, but it appears that the provision which Kate mentioned, proposed 601 LF, which will declare all funding agreements in Australia unenforceable unless they meet one of three conditions, which in turn require that the court, whether federal or state, not make a common fund order, which in further turn defines a common fund order, not as we understand it, but to include an FEO. All of that is designed to force the funder into a very narrow funnel where the scheme's constitution will require members to sign up to the terms of the funding agreement, an agreement which will not be enforceable unless the court approves it, and even then that can only happen if no common fund order is made. It seems to me that is pointing in the direction of implied repeal of the Federal Court of Australia Act in part and overriding state law, which are matters which need to be considered. There were two other aspects of the bill that I wish to say something about. The first is that the bill will make express that a litigation funding scheme as defined is a managed investment scheme, an MIS. Now, that might be thought to just be bringing Brookfield, the majority decision from 2009, plus last year's removal of the exemption into the statutory law. However, there are at least two matters that I think need further consideration. The first is that this bill, in fact, is based on premises which depart from Brookfield. Two elements of Brookfield were that the majority did not decide who was the responsible entity, but they said it was either the funder or the lawyers, perhaps both. And secondly, the Brookfield majority thought that the members of the scheme included everyone. They included the group, they included the funder, they included the lawyer who was on deferred fees. And everyone was making promises, perhaps contingent, perhaps actual, which were the contributions in money or money's worth, which constituted the MIS. Now, whatever view one takes about those propositions, in this bill, a fundamental change seems to have occurred, which is that the funder and the lawyers are not the RE. The RE seems to be a different entity which will perform the largely notional function of holding the scheme property on trust, but will not be making any of the actual decisions which will influence the success or failure of the scheme, because those decisions will be made by the funder, the lawyers, the representatives, and perhaps the court, which decides the settlement or the judgment. What has happened, and there's no attention to this in the EM, is that, as we all know, the centrepiece of the 1997 reforms was not to have a trustee and a manager, but to have a single person, the RE, a public company with an AFSL, who had the responsibility to operate the scheme. That's the term in the current Corporations Act. And that person came under duties of care and fiduciary duties when making the decisions which affected the success or failure of the scheme. That's at the heart of MIS regulation. That has been lost by this bill because the person who will be the RE will be, as I say, a largely notional entity. Now, what that might tell us is that a litigation funding scheme is not a good fit for managed investment scheme regulation. Similarly, under this bill, the members are now the people who sign the funding agreement. They are not the funder, they're not the lawyer, So it's a fundamentally different conception of what an MIS is. And I would just add finally on that one of the aspects of MIS regulation, of course, is that there are controls upon members leaving the scheme. And if the scheme is illiquid, as most litigation funding schemes would be, there are very tight controls on withdrawing from the scheme. Those controls are inconsistent with the provisions in the federal and state scheme for opt-out. So they're just one of the many areas where the two are not a good fit. So I would be saying that the cause of looking at better regulation of the industry in the interests of ultimately the consumers is a very important cause. The solution is not to force these schemes into MIS regulation, and certainly not this form of regulation. The final matter I was going to speak to, but only briefly because others may, is the rebuttable presumption and the closed list of factors upon which the reasonableness of the funder's remuneration can be considered. I hold no brief for funders, but I have to say this is a terrible proposal in two ways. Firstly, a rebuttable presumption only makes sense if there is a sound evidentiary basis for thinking that in the majority of cases it will produce a fair and sensible outcome. The way it is now worded, the 30% of the pie which is available appears to be taken on a gross basis, so that the costs have to come out of that as well. So in many schemes, there will be little or nothing for the funder, and certainly no incentive to provide the funds that are necessary to run these actions. Secondly, the closed list of factors takes an overly narrow view of what a funder is providing and the benefit the member is receiving. The only thing that can be considered is whether the commercial return of the funder is reasonable, referable to the legal costs funded by that funder. Of course, as we know, what the funder does is take on risk. The risk of having to bear all of the costs on the plaintiff's side if the action fails, plus all of the costs on the defendant's side if the action fails. The return has to match that risk. Equally, from the viewpoint of the members of the class, the benefit is not simply that if the action is successful, they get a check in the mail. The benefit is they have had their causes of action vindicated at no risk to them for costs on either side of the record. Those factors, I would suggest, need to be brought into that part of the drafting. And just finally, there's a very small point, it may seem like a technical one, but that part of the bill, which is one of its nastiest stings, to put it that way, has a provision attached to it that by regulation, the government can amend, delete, replace in any way it likes the factors which go to whether it's fair and reasonable. Now, that is a mark of much modern Commonwealth drafting, to delegate down into the executive the meaty stuff. But I would suggest that since this is in the heart of the bill, that sort of power should not be available. So I might hand over at that point.
Thank you, Justin. I've been asked to touch on in my remarks the accuracy or otherwise of the claims that have been made to the effect that this bill, once enacted, will prevent recurrence of the type of problems that were seen arising in the Banksia litigation. The report of the Joint Committee that's been the genesis of this bill did say that as a matter of showing that was pointed to that case as a way of showing or asserting that the existing regime is inadequate. And the joint report also made reference to the Banksia case in connection with the role of contradictors. And as I'll come to, the role of contradictors through this bill certainly become quite central. The Treasurer and the Commonwealth Attorney General highlighted again the case in their media release yesterday, and what they said was that by enhancing the role of independent experts, the Morrison government will also protect class members against the kinds of misconduct highlighted by the recent Banksia class action. These experts will support the courts in assessing proposed litigation funding fees and ensure that the interests of class members are properly represented. In some remarks that were reported in the media previously, both the Commonwealth Attorney General and the Assistant Attorney General may have even gone a little further and suggested that the reforms might actually prevent the kinds of issues that arose in the Banksia case. I should preface what I will say about this topic by noting that Justice Dixon's judgment was only handed down relatively recently on the 14th of October, and as such the appeal period's not exhausted, and in addition there are some further chapters of that whole proceeding to play out, as one outcome of Justice Dixon's judgment was that 2 further lawyers will have to show cause whether they are fit and proper persons. So without trammelling on those boundaries, I should say that I did note with some sense of irony that the funding agreement between Mr. Bolitho and AFP provided for, drumroll, a maximum consideration financing fee of 30% of the resolution sum. So it may not be a flying start to get away from what was perceived to be a sort of archetype of an unfair set of arrangements. But I should hasten to note that the 30% that was agreed in the funding agreement that was a subject of the Bolitho and Banksia litigation was a funding fee in addition to recovery of legal costs. In terms of the role of contradictors, I'm sure everybody's fairly familiar with how that all evolved, but the Court of Appeal approved a settlement sum, I think about 64 million, on the basis essentially that there wasn't any further money to be found, but remitted the funder's claim to legal costs and a commission to the trial division, but finding that the primary judge had erred in not appointing a contradictor, and then went back to a different judge. Now, on any view, the role of the contradictor in the Banksia litigation was extensive and involved a very deep inquiry into facts and events leading to the claims for costs and commissions, and that all occurred under the primary guise, and I don't use that pejoratively, but under the springboard essentially of whether there was what was termed disentitling conduct that should be taken into account in the approval under 33V. There was, as anyone who's familiar with the case would know, there were an awful lot of satellite disputes, and further lawyers were joined, discovery was ordered, ultimately I think over 30 sitting days. So it was not an ordinary contradictor case by any stretch, and to the extent that that case has been pointed to by reference to the role of contradictors and the way in which they prevented abuses being perpetrated or carried into effect, I'm not sure that the case is a sure guide. One would hope that it's very much not a sure guide as to what the role of contradictor will usually entail. But that's not to gainsay the utility of contradictors in what might be thought of as more ordinary cases. And in fact, state courts and the federal court have been appointing contradictors on settlement approvals with increasing frequency. But then what will be the role of these contradictors that now must be appointed going forward? I think it will be interesting to see the extent to which the contradictors and the expert appointed as referee will take at face value the bills and costs, or will feel it incumbent on them to do more than perhaps has routinely been done to scratch down below the surface and scrutinise the work that's actually been undertaken. That may be a side effect of the Banksia decision and the criticisms that were made in that judgment of the degree of scepticism exercised by the costs expert. How they would do that will obviously be a range of options, but one approach might be to do something like a bit like an auditor's sampling approach. It would certainly seem to be the case that the kind of depth of inquiry that was seen in the Banksia case would be most unfeasible and drive up costs in settlement approvals, but nonetheless finding the right balance will probably take some time to play out. I think another interesting point of intersection will be what is the best way for the contradictor and the appointed referee to be interacting with one another. The way the bill is presented seems to set them out as really two independent steps that must be taken. There must be a reference of the funding agreement to an expert for inquiry and report, and then there's a separate provision for taking the contradictor's submissions into account. But it may well be productive, at least in some cases, for the contradictor to be liaising with the referee about, for example, points that should be examined in more detail. Otherwise, you might quite rapidly find a situation where a contradictor is wanting to take a role that is more expansive and akin to that of a party, and it could lead to a proliferation of further expert reports, for example, if the contradictor considered that the referee had not explored something that should have been explored. But then stepping back from that and looking more broadly and taking the facts that Justice Dixon found at face value, what impact then will this bill have on what might otherwise be characterised as the weaknesses of the system as it stood that permitted that sort of conduct to occur? I think one point to start with, and it is a fairly central feature of the bill, albeit one that Justin has just criticised now, is that it looks to the returns to members including costs as opposed to a commission plus costs. And a number of funding agreements that have, I'm sure, crossed all our desks over time have, there's the commission, and then there's the costs, and then there's the insurance, and there are a whole lot of amounts that are deducted along the way. Whereas by flipping this around and saying, unless the members are getting 70% back, there's the rebuttable presumption that that's not fair. And it may be that Nathan will be able to comment further on Justin's point about whether leaving 30% for everyone else other than the members will mean that there's insufficient reward for funders to stay in the game. Now, there's also been changes made in the bill that was introduced yesterday compared with the exposure draft that goes further in defining claim proceeds, not only to include essentially not only that it's gross, but to include the award of legal costs and each agreement to pay legal costs in favour of members. So not only is the claim proceeds gross, not net, it now includes, it seems, costs orders. Although it's not immediately obvious how you would value a cost order in taking into account the 70%, 30% split prior to taxation. By contrast, the definition as it's been of the common fund order, as it's been amended, and as Kate touched on, it now excludes reimbursement of legal costs from the scope of remuneration of the funder. So while the definition of common fund order has been tweaked in yesterday's introduced bill to exclude apparently legal costs, the claim proceeds still include the legal costs. Another feature of the package, which is not in the bill itself, is the accompanying Corporations Amendment litigation funding regulations, which are intended to further prevent lawyers having any financial interest in the litigation funding entity. And in describing those regulations, the note issued under the authority of the Treasurer said that the amendments impose additional conditions on AFSL licensees dealing with class action litigation funding schemes. And these conditions further regulate class action litigation funders to ensure that lawyers providing services in relation to the scheme do not hold or obtain a material financial interest in the litigation funding entity funding the class action. Now, as everyone would know, turning back to Banksia, back when that proceeding commenced, the lawyers essentially owned and controlled the funding entity, and then after a decision of the Victorian Supreme Court, they had to bring in another solicitor because they couldn't keep using the same solicitor due to conflict of interest. So I'm not sure that by itself these regulations necessarily go further than the court decisions such as Bolitho number 4, which was a decision I just referred to in precluding the continuation of such dual roles. But the regulations do back up the prohibition on the interest in having an interest in a funder with sanctions, including potentially cancellation of the licence. And also, if you look at it standing back from a more structural point of view, when the focus is really on whether there's more than 30% that is going to non-members, any incentive that might have been there to effectively push costs to the maximum or push the commission to the maximum is undermined in any event, because they're going to be bundled together, albeit analysed separately, but ultimately bundled together in looking at the return to members. So just before I pass to Nathan, and I'll just touch on a couple of other matters briefly. One of the features of the bill that, as has been touched upon, is that these funding agreements are going to be unenforceable other than if they receive court approval or variation under 3 subsections, and one of those applies the subsection approval requirement to cases that don't involve any federal jurisdiction at all, that are heard by state courts. So it appears to be the intention of the bill that if there is an element of federal jurisdiction, and as we would all know, a lot of cases have a mixture, that the empowering provisions in the bill that give the court the ability to approve or vary would be available, but that in cases where there is only state jurisdiction, the funding agreement will be unenforceable unless there are powers or procedures of the court that are substantially similar to those in section 601 LG. Now, there's going to be, at some case, and putting aside the constitutional issues that Justin has referred to, going to have to be some analysis of really how close the state provisions have to be to qualify as powers or procedures of the court that are substantially similar to those in section 601 LG. And for example, would they have to include the mandatory and exclusive list of factors? Would they have to include the 30% presumption? Would they have to require reference to a report when a contradictor or referee and a contradictor? Or might it be possible or conceivable that some of the more general powers that the state courts have, including the state equivalents of sections 33ZF and 33V, might still have a second wind, subject to the outcome of the matter of whether, if I call them settlement stage CFOs, once that eventually finds its way back to the High Court, assuming that the powers are confined or are not confined to in the way that the High Court said in Brewster. And in 2 recent decisions, there's Devaria and 711 and Brewster, when it returned to New South Wales Court of Appeal, while both of those courts declined to answer the then hypothetical question of whether the Brewster decision precluded settlement stage common fund orders, the indications that were given were fairly positive in the sense that both of those courts did point to features of the High Court's judgment that really focused on the early stage common fund orders. But nonetheless, given the mandatory features of the way in which the bill is framed and the fact that the existing suite of powers under 33V and 33ZF have a much broader frame of reference, it would be a pretty tough argument, I think, to mount that they can be regarded as equivalents of 601 LG for the purpose of that part of how this bill may operate. Nathan will have a bit more to say on funding, but there were just 2 final aspects of this bill that I wanted to touch on, and one's been raised, I think, in Kate by Katie in opening. The first is that there's this sort of unspoken assumption behind this bill that the entire claims of the members are encompassed within the scheme. Whereas when you keep in mind 33C and its state equivalents, it's important, I think, to recall that you can have class actions when there's just a substantial common question of law or fact, and there's no requirement. In fact, it's expressly not required that the claims have to include damages at all. So it's not hard to think of situations where it will be very difficult to apply this fair and reasonable test when there is no ultimate resolution. And there's also variation beyond that which may have been considered by those framing this bill in terms of funding models. This bill seems to assume that you have a funder who funds the entire action, whereas in fact a number of funding agreements are set up such that the funder funds the initial trial, but then the funder is not committed to any further stages that may be required to resolve the claims of individual group members. So again, that it's not clear how that is to be addressed in this bill, and nor is it clear how what you might call hybrid funding models might be accommodated, because there are, for example, some funding agreements where the funder will fund a certain proportion of the costs and the solicitors will carry a portion of their fees, or the funder might pay for the insurance against adverse costs. It may pay for disbursements, but you can have any manner of mixed combinations involving funders and the law firms, which gives rise to the question of really what's the intended carve out from the definition that sets this all up of the when you will have a scheme, because that excludes or appears to exclude where the funder is the lawyer. So it assumes a single funder, and it excludes lawyers, but it doesn't seem to really grapple with the situation where you might have a mixture. And nor is it really clear to me, at least, that there's a very neat dividing line between how this bill will interact with the Victorian group costs order provisions. But I'll let Nathan speak to the Victorian group costs order and the funding topic more broadly. Thanks. I'll pass to you, Nathan.
Thank you very much, Justice Button. Good evening, everyone. I'm going to touch on a few of the particular features of the bill, including some of the key definitions, and then focus on how the bill might operate in the context of open class actions, and talk about what impact they might have on the availability of common fund orders and funding equalisation orders, and discuss a little bit how the process of obtaining approval of the claim proceeds distribution method might work, and in that context talk a bit about the rebuttable presumption. To begin with, the first key term in the bill, and Kate touched on this at the beginning, is this term class action litigation funding scheme. One observation that we made of that definition relates to some of the discussion that's emerged, particularly in the context of Banksia. It's been argued by some that funders and lawyers can be more focused on benefiting themselves through class actions rather than obtaining compensation for group members. And Banksia might well be the most striking example of that. But if that were true more generally, then there's actually a very large loophole in this bill, because to be a class action litigation funding scheme, there must be a scheme, the dominant purpose of which is to seek remedies for the claimants. So there seems to be at least a recognition here that that indeed is the dominant purpose of the scheme. Ironically, it could be argued that some of the worst kinds of schemes that have been seen, and some might recall there were proceedings that were found by the courts to have the dominant purpose of generating fees for solicitors, not seeking remedies for the applicants and group members. Ironically, those schemes might not be caught by this regime at all. Putting that aside, though, as has been touched on, the definition is very broad. It's not limited to class actions. It's not limited to court proceedings at all, or it might be a proceeding in one of the inferior courts if there were 7 plaintiffs, although that might be fairly uncommon. One thing the bill won't capture, though, is no-win, no-fee proceedings that might be run by a law firm, and it won't capture what starts as a no-win, no-fee proceeding in the Supreme Court of Victoria, where an application is then made for a group costs order under the recent reforms in Victoria. The reason for that is in those cases there would not be a funder who by definition is not the lawyer providing funds or indemnities or an agreement to enable the claimants to seek remedies. I think even if a law firm had a portfolio finance arrangement in place with a funder ostensibly, I don't think that would be caught, because one wouldn't normally expect that that portfolio finance arrangement is to enable claimants to seek remedies. That would be more simply the way the law firm finances its activities, just as it might, with a bank loan, effectively. Question is, when does a class action litigation funding scheme come into existence? It's probably, I think, when a funding agreement is entered into. Perhaps it's enough that there is one person who is entered into it. The scheme will need to be registered before it can be promoted. So the reality is it will be registered before anyone signs up to it, before anyone might retain a law firm or enter into a funding agreement. Although as has been touched on, the explanatory memorandum says that it is not intended that members will enter into funding agreements, although if you read the bill, there's nothing in the bill that actually would prevent that. What seems to be contemplated perhaps is that it might just be the responsible entity that enters into a funding agreement with the funder. Probably the lawyer would also be party, and it might be contemplated that the responsible entity will hold promises from the funder on trust for members. Those promises might be to pay the members legal costs, to pay security for costs if required, and to pay any adverse costs if ordered. The next key term in the bill is class action proceedings. That again is broader than a class action as we know it in terms of one under Part 4A or its state equivalents. But it is probably limited to a proceeding in one of the superior courts, because the bill uses the term capital C court, which Corporations Act defines effectively as the federal court and Supreme Courts. The requirements imposed on the constitution of a scheme will apply before there is ever a class action proceeding, but then much of the bill, and particularly the new provisions about enforcement of funding agreements, will only apply if a class action proceeding is commenced. But as mentioned, that won't necessarily be a class action, but certainly in the ordinary case that we're familiar with, it will be a class action. So I'm going to focus on when it is a class action. My observation reading the bill is that it can operate alongside Part 4A and its state equivalents. It certainly doesn't expressly purport to amend Part 4A. It obviously can't directly amend the state equivalents. I will confess I haven't considered, as Justin has, to that degree, the question of implied repeal of Part 4A, but I thought when reading it that it could perhaps be made to work sitting alongside Part 4A. It may be, as has been mentioned, it's not fully effective to achieve some of the stated purposes that have been expressed in the explanatory memorandum and the Treasurer's press release and so on. But taking as a starting point that it doesn't expressly amend Part 4A. If it doesn't affect any implied repeal, what that would mean is certainly, as Justice Budden touched on, one can still commence an open class action. Section 33C and its state equivalents still will permit an applicant to commence a class action on behalf of all persons who have a claim of the requisite kind, same, similar, or related circumstances, and so on, even where that class action will constitute a class action proceeding under this bill, and there will be a class action litigation funding scheme, and even where there will be group members in the class action who are not members of that scheme. The bill and explanatory memorandum quite clearly acknowledge that there may be claimants in the class action proceeding who are not members. The definition of class action proceeding, for instance, expressly says whether or not remedies are also sought in the proceedings for one or more other persons. So I didn't discern in this an intention to prevent open class proceedings. It seems to be quite clearly acknowledged that that might still occur. Similarly, I thought reading the bill that it doesn't cut down the powers the court has to make common fund orders and funding equalisation orders. Aside from the new express power to approve or vary the claims claim proceeds distribution method, the bill, the provisions of the bill are not really directed to courts at all. They impose requirements on the constitution of an MIS and on the enforcement of a funding agreement. The only respect in which the bill kind of speaks to courts, aside from that new express power, is in a provision that was added that wasn't in the exposure draft, making clear that it is not intended to imply that a court does have power to make a common fund order. But I thought reading the bill that it doesn't do the opposite either, and that is it doesn't imply that the court does not have that power. In fact, what the bill does, I think quite frankly, is acknowledge that the court may have that power. One could say if the power didn't exist, it would have been unnecessary, or if it certainly didn't exist, it would have been unnecessary to make as a condition of the enforcement of a funding agreement that a common fund order is not made. So I thought that the power, if the power exists, and of course the High Court hasn't yet had a chance to speak decisively on that question, but if the power presently exists, I thought that this bill won't change that. The same, I think, applies in respect of funding equalisation order, but I might return to that a little later. The next, I think, key provision in the bill is claim proceeds. And one thing that the explanatory memorandum doesn't really recognise, and the commentaries I've read in the bill I don't think have addressed, is that at least in the case, in the case of an open class action, I don't think the definition of claim proceeds is actually synonymous with the total settlement or judgment obtained in the class action. One simple reason for that, and the simplest, is simply the definition refers to remedies obtained for members. And of course, members are defined as people who sign up to the scheme and agree to be bound by the Constitution. But beyond that, and if there be thought to be doubt about the definition, the bill doesn't really work, I think, if the definition of claim proceeds actually captures the entire settlement or judgment in a class action. It is an open class action where there are claimants who are not members. There are a few reasons for this that I'll just touch on. One is that if claim proceeds were the total settlement, then one would certainly expect that claimants who are not members will receive a portion of it. Yet the bill doesn't distinguish between someone who is the funder and the lawyer and someone else who is not a member but is the claimant. So, for example, the requirement that there be a claim proceeds distribution method in the funding agreement, the Constitution will have to say that there must be a method. That speaks of a method for determining the amount that anyone who is not a member will receive from the claim proceeds. Now, a claimant who is not a member answers that description of someone who is not a member, but there's certainly no intention that can be discerned that the funding agreement should specify how it's to be worked out, how much those claimants are to receive. In fact, one of the changes between the exposure draft and the bill is to make clearer that it is not intended that the method deal with working out individual member entitlements. It is only to work out how much non-members are to receive. Secondly, one of the new requirements added since the exposure draft is that if anyone who is not a member is to receive any of the claim proceeds, the Constitution is to say that they must be a party to a funding agreement. Now, of course, a claimant who is not a member certainly is not going to be party to a funding agreement. So the funder couldn't really specify a method that was to give any of the claim proceeds to non-members who are claimants. Yet if we skip forward to when a proceeding is resolved and it's an open class action, if approval were to be sought for a methodology of distributing claim proceeds that gave some money to the funder and lawyers and some money to the members and no money to all the other claimants, it seems very unlikely, firstly, that method would be approved by the court, or even if it were under this new power, very unlikely that the court would approve the settlement under Section 33V. So I just don't think the bill is intended to capture the whole settlement amount in a proceeding where it is an open class action. What that means is that really before you get to how the bill deals with claim proceeds, and particularly the rebuttable presumption, you would need to work out what are the claim proceeds, and that would be the portion of any settlement or judgment that is for the members, the signed up members. As has been mentioned, legal costs are expressly included in the definition of claim proceeds. I think that was designed to ensure that they're just brought into the mix, even if there is particularly an agreement from a respondent to pay costs on top, they now count. In the more common scenario where you have a global all-in settlement, the first step effectively will be to work out how much of the total settlement is claim proceeds, being amounts obtained for the signed up members, and how much is for the other claimants. Ordinarily, legal costs and other costs of the proceeding would effectively come off the top almost before you would divide it up, kind of as a first charge. I think the claim proceeds, the costs that come off the top would be regarded as claim proceeds obtained for members, because it's obviously the members, the signed up ones, and perhaps even just the applicant who has incurred the costs or on whose behalf the costs were incurred. I don't think it'd be right to say that the costs were incurred on behalf of people who haven't entered any agreement to incur costs. So effectively, I think the claim proceeds will cover the costs that have come out, whether they are coming out of global sum or have been paid on top, and the portion of the settlement that is worked out is that signed up group members are entitled to. One consequence of that is that when you come to apply the rebuttable presumption, you're looking at whether people who are not members, now that's really going to mean the funders and lawyers, are receiving 30% or more of that claim proceeds. Claim proceeds then won't be the total settlement. Now, we're all very familiar with the courts examining how much of a settlement will go to legal costs and funding commission. in the process this bill sets up, the court would probably alongside that also have to consider how much of the portion that belongs to the signed up members is to go in legal cost and funding commission. It's not really clear what purpose is served, I think, by having that focus rather than focusing on the total settlement. The explanatory draft, I think, was a little clearer in making clear that the claim proceeds was not the total proceeds of a settlement. One way I think it made that clear was the contrast when it defined a common fund order. It talked about the total amount received or obtained as remedies for anyone. That wording has been deleted, but I think the best interpretation remains that claim proceeds is only the portion of any settlement or judgment that would go to the signed up members. I'll come obviously to approving the claim proceeds distribution method, but let me just touch on funding equalisation order on the assumption, firstly, that a common fund order is not even sought, but then the second assumption being that the method in the funding agreement is approved by the court. Absent some intervention of the court, the burden of that approved method would only fall on the signed up members. Now, the High Court in Brewster, I think as much as commanded that funding equalisation orders be made, certainly in the plurality judgment, there were statements to the effect that approving a settlement where the unsigned members get a free ride, don't contribute, get a windfall, effectively that would not be just. So I would still expect, and I think we should still expect courts to make funding equalisation orders to deliver that justice and ensure that there is that level of equality between signed up members of the scheme and all other claimants in an open class action. Although there are statements in the explanatory memorandum, and Justin referred to one that might suggest there is an intention to stop that occurring. There are also statements later on. There's I think a supplementary regulatory analysis attached to the explanatory memorandum that speaks of these new power to approve or vary the funding agreement as complementing the existing powers to make funding equalisation orders. I think that analysis certainly indicates that it's contemplated that funding equalisation orders will still be made. I personally will be surprised if the courts accept that this bill has prevented them from making those orders to ensure justice between group members. In terms of common fund orders, the most direct impact of the bill is that if a common fund order is made, then the funding agreement can't be enforced. Now, of course, if a common fund order is made, a funder doesn't need to seek enforcement of a litigation funding agreement, and it would be unthinkable, frankly, that a litigation funder would ever have sought to enforce a funding agreement if a common fund order were made. Just on the definition of common fund order, I think one can discern there that it's not intended to capture a funding equalisation order. It talks about the purpose of the order being to fix the remuneration of the funder, whereas I think a funding equalisation order, its purpose is not to fix the funder's remuneration. It takes it as a given, albeit now it may be approved or varied by the court and spreads it across the whole set of claimants. Touching then on approval of the method, I think this is the most significant impact of the bill, that the court now has an express power to approve or vary the method in the funding agreement. I don't think that's a radical change. From our observation, many judges have already considered that Section 33V gave them the power to do that. This makes clear that there is that power. It certainly circumscribes how that power is exercised in terms of an exhaustive list of factors and entrenching the role of a referee and contradictor, albeit the court can dispense with them in a particular case if it considers that appropriate. The rebuttable presumption, as I've touched on, poses some complications in applying it in an open class action. One of the curiosities I found reading the exhaustive list of factors is these are factors for the court to consider when determining whether the method is fair and reasonable, that being a method for working out how much the funder and the lawyers that are received from the claim proceeds. A common method will be that, and let's take a simple case where the funder has paid all the legal costs. The method might be that the funder receives reimbursement of the legal costs it's spent, at least those that are approved as reasonable, plus a percentage of the claim proceeds. Let's pick a number and say 20%. So that's the method, that kind of combination of two amounts that the court would be asked to approve as fair and reasonable. And one of the curiosities that struck me is that the list of factors the court is to consider does not actually include the proportion of the claim proceeds that the funder or lawyers or any non-members would receive if the method is approved. So I thought that this bill won't create too large an obstacle for the rebuttable presumption to be rebutted in an appropriate case where there is good reason for it to be rebutted. Probably the most common reason why a greater than 30% portion of the claim proceeds, and we can even here consider just a closed class for simplicity, why more than 30% might go to the funder / lawyers if there are unpaid legal costs, will be the amount of the legal costs. The court certainly will be considering the amount of the legal costs and the reasonableness of the legal costs. But if the result of the amount of the reasonable legal costs and the funding commission, which let's suppose in isolation the court considers reasonable in that the court considers the amount of the claim proceeds, the amount spent and risked by the funder, the amount of the legal costs, and sees that the commission is appropriate. On one view, the court isn't even allowed to consider, well, how much of the total claim proceeds will this method result in the funder / lawyer receiving, or if it can consider that, it's, I think, not difficult to imagine that the court could be persuaded that a method of the funder getting back what it spent plus a reasonable commission of, say, 20% might well be reasonable, considering the interests of the scheme's members, even though that may result in a greater than 30% return going a greater than 30% share going to the funders and lawyers. I'll just say one more thing on common fund orders. The bill, I think, and I think the second reading speech suggests that the need for common fund orders is superseded by this express power to approve funding commissions in funding agreements. To the extent that common fund orders have been used as a way to effectively ratchet down what the court considers a too high funding commission, that's probably true. But there will be cases where the funder, if all the funder did was seek approval of the method in the funding agreement, the commission to the funder would be negligible. There will be cases where it's simply impractical to imagine that members in large numbers would sign up. We're running superannuation class actions, for example, that have many hundreds of thousands of members. Their individual claims are very small. People are notoriously dispassionate and disengaged when it comes to their superannuation. Many of our cases are being run with the support of a litigation funder. in those cases, it will be a scheme, and if the cases were commenced under this regime, it would need to be registered as an MIS. There would need to be a constitution. The only members would be, in some of our cases, would be the applicants as the only persons who have actively signed up. It's a bit nonsensical to speak of the funder receiving a commission solely from the applicants. So you could still have a situation where the funder comes to court at resolution after having expended significant amount in costs, where the claim proceeds being the share of the settlement that the applicant or the applicant and small number of signed up members are entitled to is very, very small. A commission from their share would therefore be very, very small. You will still have the ability, I think, for the funder to come to court and ask to be awarded just remuneration under Section 33V if there is a settlement for having expended significant costs and taking on significant risks for the benefit of group members, without which possibly a very large settlement for all group members wouldn't have been achieved. In my view, this bill doesn't really weaken the case for the funder if the power is there and the power is not altered by this bill. So in that respect, it may be the bill doesn't fully achieve some of the stated purposes that have been spoken of in the extrinsic materials. I think the fundamental reason for that is that those purposes are not fully effectuated in the actual language of the bill. Plainly, if the government wanted to completely prevent common fund orders, at least in the federal sphere, it could certainly amend Part 4A, and this bill doesn't seek to do that. Thank you all.
Thank you to all the speakers. There are a few questions, but I'm noting the time, which seems to be already over the allotted time for the conference. I suspect that other than one question which the speakers won't be able to answer, which is about the politics of the bill, possibly will it pass both houses of parliament, which I'm not sure you will be able to answer, that you've really covered all of the questions apart from one which relates to the grandfathering provision in section 1688. But it seems to me that provision in its terms is relatively clear. So I was going to hand over to Justice Bosanko for the vote of thanks.
Yes, thank you, Justice Jago. Ladies and gentlemen, I would like to propose a vote of thanks on your behalf and on behalf of the Academy to our speakers and our chair for what has been a most interesting and stimulating discussion and debate. As we have seen, our speakers tonight, Justice Button, Justin Gleeson, Kate Morgan and Nathan Rappaport, are all eminently qualified to speak on the matters they have addressed. At least 8 to 9 areas have arisen where I have a number of questions, ranging from the constitutional matters to the constraints on the court in applying the fair and reasonable test. Time does not permit me to mention all of those matters. Whatever our particular areas of interest, I'm sure all of us have come away with much food for thought and a number of valuable insights into the proposed legislation. Once again, to our speakers and chair, please accept our thanks and be assured that if we could clap, we would all do so with sincere enthusiasm. Ladies and gentlemen, that concludes the proceeding this evening. Thank you for your attendance.